Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
Breaking all the patterns, facts and theories, clues and controversy. Join the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way. Truth never fails. Now get ready for this live stream. Super chat, highlight your message. Don't fall victim to the irrelevance. Hit that, like, share, subscribe to Marv's Beyond the Evidence.
All right, let's try this again. Good evening, everyone. How are you on this cold, chilly evening? As you can see, I am all bundled up. I've got sweatpants on, I've got sweaters on, and I have my big bathrobe on. So bear with me tonight because it's cold here. So today it dropped. Got some documents dropped from Fran Gull about the exhibits. The requests, the FOIA requests that are coming in for the exhibits and the transcripts. And boy, with true Gull fashion, what a crock of shit. But I'm going to let her tell you about it. So let's take a look at this. And after this, we'll discuss it.
I am the Carroll County Circuit Court. The court is now on the record in cause number 08C01-2210-MR-000001, State of Indiana versus Richard Matthew Allen. I am the Special Judicial Officer, Francis Gull, appointed from Allen County Superior Court. After reviewing pleadings filed by Media Public regarding Indiana's Access to Public Records Act under the Indiana Constitution, the court notes the DIS law, in conjunction with the United States federal laws regarding pleadings often referred to as Freedom of Information Act. The court has reviewed the request and taken the matters under advisement. The court carefully considered the requests and issued its ruling as follows. This matter comes before the court on the following motions. NBCU's motion to intervene and to compel access to public trial exhibits, filed by NBC Universal on February 3rd, 2025, and Media, LLC, and Twist Media, LLC's motion to intervene and to compel access to public trial exhibits, filed on February 7th, 2025. After careful consideration, the court makes the following findings and enters this order. 1. NBCU produces Dateline NBC and emailed a request for public records on January 8th, 2025. 2. This court and the court reporter have received thousands of emails regarding this case. The court has no means of verifying the true identity of individuals representing themselves as media or any other entity by email. Merely claiming to be NBC, ABC, PBS, or CBS does not confer such status. 3. A representative purporting to be from NBC requested that the court reporter prioritize their exhibit requests. 4. This court refuses to allow the media or the public to dictate its schedule or work responsibilities by making priority requests. No authority has been advanced by NBC or Twist Media LLC to justify such a demand. 5. The court reporter has not denied the requests, but has indicated that the exhibits are necessary for the production of a transcript if requested by the parties. 6. The exhibit volume is currently contained in 2 banker's boxes and required several weeks to catalog and organize. The court reporter estimates that once completed, the volume could exceed 15 volumes and will require additional weeks to prepare both the confidential and non-confidential exhibit sets. 7. Requiring the court reporter to retrieve and evaluate materials from these boxes to ensure that no confidential information is released will interrupt the process and force the reporter to request an extension of time or multiple extensions from the Indiana Court of Appeals to file the transcript. 8. The requests for public trial exhibits are vague and overbroad. They do not specify exactly which exhibits are being sought, and the court reporter will not attempt to infer the media's or public's intent. 9. The media public is requesting any and all recorded police interviews with Richard Allen, video and audio. This request is overbroad, vague, and lacks specificity. Which interview is being requested? 10. The media public is requesting any and all recorded prison phone calls between Richard Allen, his wife, and his mother, audio. The court is not in possession of any and all recorded prison phone calls. Which specific calls are being requested? 11. The media public is requesting the 43-second cell phone video clip recorded by Liberty German. This request is not sufficiently specific. 12. Which exhibits, specifically, is the media public requesting? 13. The court notes that the press pool for jury selection and for the trial was well managed by Cindy Hebert of WTHR Indianapolis. Ms. Hebert coordinated with the Hoosier Press Association and the Indiana Broadcasters Association to ensure comprehensive media coverage of the case. 1212 press passes for media, as defined by IC 3446-41, were provided to her, and she implemented a pool lottery to guarantee ample coverage for all media outlets. The court thanks Ms. Hebert for her diligent efforts. 14. 22 credentialed media representatives from local, state, national, and international outlets were allocated press passes to ensure full representation in the courtroom. The media was assigned to the front rows, and additional public seating was provided, though this was met with displeasure by some podcasters, YouTubers, and true crime enthusiasts. A coalition of international media was present and appreciative of the access provided to all exhibits. 15. At the conclusion of each trial day, all credentialed media were invited into the courtroom's central area, the well, to review the exhibits. 16. The media outlets present at the trial included NBC, Marianne O'Donnell, and NBC Indianapolis, Carroll County Comet, Kokomo Tribune, Indianapolis Star, Lafayette Journal and Courier, Wish TV, Indianapolis, WRTV, ABC Indianapolis, Fox 59/CBS4, Fox CBS Indianapolis, Wayne TV, Fort Wayne, WPTA TV, Fort Wayne, WSBT TV, South Bend, WNDU TV, South Bend, ABC. 17. The court notes that representatives from Dateline NBC, including Marianne O'Donnell, were present, had access to exhibits, and presumably witnessed the playing of audio exhibits for the jury. 18. This court is among the busiest in the state of Indiana, managing over 25 murder cases set for jury trial, in addition to hundreds of other major felony cases, including charges of murder, attempted murder, rape, child molestation, robbery, burglary, arson, and corrupt business influence. The court observes that the motion filed by Twist Media LLC is virtually identical to the pleading filed by NBCU on February 3, 2025 at 4:31 p.m. 20. The motion filed by Twist Media LLC does not attribute any of its allegations to NBCU and appears to be plagiarized. 21st. Twist Media LLC is not considered media as defined by IC 344641. Accordingly, the court treats its request as one submitted by the general public. 22. If the media or public submits a particularized and specific request for an actual exhibit introduced at the jury trial of this matter, the court will make that exhibit available on a date to be determined. 23. Upon receipt of such a particularized request, the court and the court reporter will schedule appropriate dates and times, despite the extremely busy calendar, to accommodate the request. The media and public cannot expect the court or the court reporter to infer precisely which exhibits are being requested without clear guidance. Wherefore, the court hereby conditionally grants NBCU's motion to intervene and to compel access to public trial exhibits, and conditionally grants the general public's motion to intervene, subject to the requirement that specific particularized requests be submitted for the court's consideration and proper accommodation. Dated February 18th, 2025. So ordered this 18th day of February 2025, the Honorable Judge Francis Gull, order in the court. I said order. Now sit back and relax, YouTube, Facebook, or wherever the hell you're watching from. Today we go beyond the evidence and rewind the case to the motions to intervene. Marv and Anthony Greeno are about to discuss my newest order in the Delphi murders. Why, you might ask? Because justice matters.
You got that right, Judge Gull. So we have put in specific requests for the exhibits. We do not have all the exhibit numbers. The mainstream media that she's talking about that had front row access didn't provide the exhibit numbers in their documentation of the trial. Nobody did. We were too busy trying to write down what was actually being said. So now you're telling me that I have to put in a FOIA request and put the exhibit numbers in there to make it easier for you? Bullshit. My job is to put in a general public request. It is your job or your clerk's job to go and find that exhibit and send me an email stating how much I'm going to be charged to receive it so that I can make a payment and get it from the clerk. That's my job, and that is your job. This BS of media saw this stuff. Oh, how nice. Maybe they did, but the rest of us want to see it. The rest of us want to hear it. The general public has the right to see these exhibits and videos and listen to them. And they have all sorry about that, hit the wrong button. And they have all the exhibits listed. So if I put in a request that says the original video, 43-second video from Liberty German's phone, they have a list of that. They should be able to look. Original video. It's this exhibit. This is what she wants. I shouldn't have to put the exhibit number on there. That is a crock of shit. And I'm sorry, Judge Gull, but you did this to yourself. You did this to yourself when you tried to strong arm everybody and not televise or provide the audio to this trial. You did this to yourself when you tried to make it difficult for individuals to get into the courtroom. You expected us to fight amongst ourselves so that you could throw everybody out. And when we band together and said, no matter what, it doesn't matter what side you're on, doesn't matter who you're for or against, we are going to look out for one another during this process, because we knew that's what she was trying to do. We're going to look out for one another and make sure we get through this together. That's exactly what we did. Bygones were put aside. Animosity, fighting, all put aside. We worked together. Each and every single one of us that was there every day worked together to look out for one another, make sure people were being fed, make sure they were getting drinks, making sure people were sleeping, taking turns, standing in line, saving spaces. You betcha, it happened, because that is what we were forced to do. And now she's bitching and complaining because she's got thousands of requests. What the hell did you expect was going to happen? Of course, you're getting thousands of requests. Release the shit and it'll stop. Enough is enough. Okay, so I glanced over and I looked at the comments and I saw, you need a hat, the heat is escaping. Yeah. Mr. Scott, I have had enough of all this bullshit with this case. These are the things that Oh, sorry about that. These are the things that I want. I want transparency. Release the transcripts so that we can pay the thousands of dollars and get them for ourselves so everybody knows exactly what was said, because there are many, many people misinterpreting and misstating what was said in that courtroom. Second, release all of the exhibits except for the crime scene and the autopsy photos. Those do not and should not be released. Number 3, somebody needs to bring in some special investigators in this case and give them every terabyte of information from the prosecution and the defense. And those special investigators need to go over every piece that has ever been accumulated. And once and for all, tell us what the fuck actually happened. Because enough is enough. You know, you get a couple things happen and you're like, oh no, defense is wrong. But when they continually bring up stuff about what the prosecution has done or not done or kept or whatever, then I say that's suspicious. Does the defense always tell the truth? Absolutely not. But until I see it for myself and I can read what happened before, during, and after, I can't say who's right. And the families deserve and want the truth.
It's okay if you want to use the word theory, but you got to back it up with evidence. And if you want that theory to become a truth, you got to have evidence to back it up. And we live and die by the burden of proof of beyond a reasonable doubt. And so if you can prove a theory beyond a reasonable doubt, then to me it becomes a truth in the court of law. And until then, it's just a theory, and that's just what it is. It's an idea of what you thought happened. And so I don't have a problem with people throwing that word around, but where's the evidence to back it up?
There's been so much time where neither side had an opportunity to say much. It was under the gag order, obviously, for quite some time. What to you did the gag order mean?
Gag order to me was just a reiteration or a re-emphasis on the rules of professional conduct that we're bound by. And that is that you should not put out anything in the public that's going to try to taint the jury or elicit a response from the public. And we're bound by those rules. And the gag order is just an emphasis of that to say, don't talk about this case in the public. Don't put out press releases that try to, condition the public to whether Richard Allen was guilty or innocent. And mainly that was done so that we can get a jury that's not tainted or biased. I really had a fear that we were, regardless of how many people that we subpoenaed in to be for jury duty, that we weren't going to find 12 that hadn't heard about this case.
Well, you need the truth first, Mr. McClelland. Did you get these letters from Reese Davis? If so, did you give them to the defense? If not, your ass better be on the line. Because it's things like this that keep this case going forward. In my opinion, Gull needs to go. Nick McClelland needs to go. The defense team needs to go. And if the Supreme Court decides there should be a new trial, it should be an brand new team. Judge, prosecutor, and defense team. And in the meantime, while we're waiting for the Supreme Court to look at this and see whether they're going to hear it and make a decision, they need special investigators to go in there and look at everything to determine if the prosecution did things wrong, if the defense is just blowing smoke up our asses. Something needs to give. Oh, we did take a lot of notes. I've got 3 freaking notebooks filled. I'm pretty sure there was more than 60 exhibits in that trial. What the hell does Gull mean when she says the request for the 43-second video isn't a specific enough request? Exactly! We actually put Libby German's 43-second video. And we asked for the original. And then we also asked for the enhanced. So how can you tell me you don't know what the hell that is? Nobody has an itemized list. Not out here anyway. The lawyers do. The judge does. The court does. Oh, I know that they don't know what we went through. Yeah, we did, Jackie. Absolutely. I think some people just don't want to stop making videos about this case. It's not about that, Adam. It's about the fact that every time we think it's done, something else comes up and makes you go, where was that information during the trial? Why wasn't that allowed? Why wasn't the defense given this information? Did the prosecution hide it? There are too many things now in the years that this has gone on from pre-trial to after trial, there are too many coincidences, and it all needs to be looked into. Let's see. Snow. We only got 4 inches of snow. It's the cold that needs to go. With my fibromyalgia, it gets in my bones and I just hurt. Not just the letters. Where's the video of McClellan at the prison when he went there to talk to Reese? Exactly. I don't think they will. Marv 100% agree. This is crazy. He may be. He may be. I feel that based off of what the jury was allowed to see and hear, they made the correct decision. But now I find out that this Reese Davis was saying all this stuff about Ron Logan. Frank and I talked about Ron Logan extensively. He was one of the people, the rabbit holes that we went down. Now he's saying that Keegan Kline told him all this stuff. Well, now, according to Tom Webster, Keegan Kline's denying it. But we know that Keegan Kline lies all the time. So which one is the truth? I dropped a juvie on my cat like an hour ago and still... Oh, you're funny. I do believe there was between 125 and 130 exhibits. But I have not had a chance to go back to back through my notebooks. I'm going to be doing that tonight and tomorrow morning. Hi, Kenny. How you doing? Yeah, Misty. Things that make you go, And if you guys think that this case is crazy, this isn't the only crazy case. It's not. Okay? You've got this case. You've got the Tabitha Shuck Raines case. You want to talk about crazy lately? Karen Reid trial. Sebastian Rogers missing person case. They're all making us go out of our freaking minds because we don't know and can't get factual information. And that is driving us crazy. On top of, you have all of these beautiful children being killed by their parents, being killed by step-parents, and others that they don't know or they do know, and it's so much so quickly, it just gets to you. And sometimes you just can't get past all of it. It just compounds you. And it's crazy. Curious, contrarian, thank you so much. I appreciate it.
And mysterious world of the missing and murder. You seek the answers, but you never know what you'll find last. When you rewind, this is the true Crime Rewind podcast. This is the True Crime Rewind podcast.
Hello, Anthony.
What's going on, Marv? How you doing?
Good. I'm ranting a little.
I see that, and you know what? I am ranting right alongside you because I am just heated over her response. The judge is just making us jump through hoops when I specifically requested in my motion that they didn't even file onto the record after sending it to them multiple times. They are not being right with this, and that's very upsetting.
No.
We should have a right to have that stuff without delay, just like we can call and get somebody else's court document right now without question. We'll get it somewhere else, and they're being so secretive about everything, and it's starting to concern me.
I have never had this much trouble with a FOIA request, except for the fact of Tipton and the Tabitha Shuck Raines case.
Right.
Any other time, they're allowed so many days to get me my request, and they tell me how much I owe for it, I pay it, and they send it to me.
And here they won't do anything like that. They will tell you, oh, you can't, you got to be in person, okay, is what they told me the first time. The second time was you have to fill it in writing, okay, so I did that. I specified.
Now we're not going to do it in person. So,
and it's like, okay, by law, the law says that you have to do this, this, and this. And so
we should be able to get it by email, mail, or in person.
Yeah, exactly. You should be able to get any of those, and you should have to pay for it, right?
Yeah.
And there should be a set price for videos, audios, depending on length and stuff like that. It should have set prices, not just whatever they say, because as we've seen before, they're obviously not doing something adhering to all the laws, because they were in error when they were trying to charge $5.75. Remember that?
Yeah.
So, and the law clearly states that they can change the amount charged, but they can only charge the $5.75 one time for everything as a one-time fee. But no document was to exceed $1, and they wanted almost $4,000 for 750 pages.
Yeah.
That's ridiculous. That's ridiculous.
I mean, I don't think everybody understands how expensive these transcripts are going to be, even paying $1 per page.
It's going to be a lot of transcripts, because there was a lot of talking going on in there, and all the sidebars that we just sat around. Oh my gosh, there were so many sidebars on some of those days, like the day the crime scene photos were shown when we were in there. And
remember the day that McClellan wanted to play the video of Richard
day one
in the what was the place he was transferred to?
Westville.
No, the one after that.
Wabash Valley.
Right. So we get in the court, and we have a little bit of stuff happening, and then all of a sudden McClellan's like, well, I'm going to play this video. And the defense objects. We have a break.
Yep.
Come back. Judge Gull says she needs to see this video then in her chambers. We have another half an hour, 45-minute break. Go back in. They talk a little bit. We have another break. I mean, we were on break for almost 2 hours that day.
You know what? And then that one day when they were playing the videos and they said these are excluded from the public. Now, these are the only things that we shouldn't be able to get access to, because they weren't shown to us. They were only shown to the jury, some things.
Right.
But I believe that if I sat in there as a member of the public, as a member of the community, and I watched all of that, and I saw the things that I saw, like the bridge guy video, the enhanced audio, all that stuff, minus the crime scene photos, which she did seal, crime scene, autopsy, and his mental health.
Right.
That's all that listed in the order. So they can't tell us that we can't have those. And the judge's own order, she wrote requesting public trial exhibits. So she's acknowledging that it is public trial exhibits.
Right.
So why is it such a fuss to go get them? And then they say only media can get them. Why? Why only media? What is that?
There's nothing in the rules that said only media can have that.
That is discrimination.
Media request for the general public, not media request.
It's I mean, we are requesting it. You know, I did request it in writing. I specified in. Do we have a copy of that?
I told you what to write in there.
It's that
the actual description of each exhibit I wanted.
Hold on. We're gonna. Do you have a copy of it, of the one to intervene? Let's see here. What's up, everybody? Judge Fran
Ron Logan, you're
won the bowling tournament last week.
I gotta have some stuff that will make me calm down and laugh a little bit, because this stuff is really starting to get to me. I think with everything that we went through last week and all the cases that I've been watching that are just breaking my heart, and then dealing with the continuous bullshit from this case, and trying to research other cases to bring to this channel, I think I'm just very, very overwhelmed at the moment. And
it's easy to get overwhelmed.
I am ramped up. I lay in bed at night and all of these things are running through my head. I can't sleep. I'm up till 4, 5, 6 o'clock in the morning. And then I try to sleep for at least 3 or 4 hours. So the sleep thing has to get fixed too. So yeah. Wax on, wax off. Yep. We are the media, but we are not the media in Gull's eyes.
Now, that's why we should pull up that motion of mine, because I talked about that and I cited case law with that.
You have to tell me which one it is.
Okay, so there's several motions, and what we're talking about today is the motions to the intervene. NBCU filed one, Twist Media filed one directly after, and I filed one directly after that. Yes, but they didn't put mine on the record, but they have it. So it is. Let me look at the email. Let me see here. I think it would be in the email, maybe. Or, yeah, it would probably be in the email, I think. So.
Okay, so one of the things I have here.
Okay, that's it. I think that would be, or maybe. What are those? Okay, so that's NBCU's exhibits.
Yeah.
Yep, NBCU's exhibits showing correspondence with the clerk of court when they were asking for the documentation.
Yep, Jody Williams.
Yep. So that's it right there, everybody.
And then Exhibit 2.
Yeah, Exhibit 2 is.
Can everybody see this?
Kind of, not really. I think we need to make it bigger. I'll make it bigger if I can.
All right, let me know if that helps.
Yeah, you know what? That's a lot better.
I've received a request for documents. All documents listed below would have to be requested through Jody Williams, Allen County. These documents may or may not be available. That will be up to the judge. Why is it up? It should not be up to the judge.
It's not up to the judge. The judge can't just say that these things aren't available when there's no court order.
Right. There's nothing keeping them secret. It's all public.
Exactly.
All public knowledge and be able to be given to the public without the judge's approval, because she has not sealed anything.
Nothing except the crime scene photos and the other things. And it says it right in the order of hers.
Right.
You know? So then I think the next one, let's see, that's going to be Twist Media's
Yep.
version. Okay, so Twist Media wrote a version, and then wait till you hear what she says about that, or what she said about that. She said it was
Plagiarism.
plagiarism. It was plagiarized off of NBCU's, basically copied.
So what?
Yeah, exactly, and that's what I don't get. Is like, okay,
For a
so what
FOIA
if they
request,
copied it?
we all do that.
It's a very similar. I was going to say most of the court's forms are all very repetitive. So for someone to, I don't know, I don't see why they're trying to say that right there. What's that?
This is
That's their motion. So that might be a good one to. How long is that one? A couple pages?
Yeah.
That might be a good one to talk about, because what they're asking for, ladies and gentlemen, and they're citing law in here, and same thing with me. If you guys have seen these documents, you haven't seen mine. I had a video on it, but we do have it in here somewhere. I got to figure out where the hell it's at.
Okay, so now number 3 is asking for them to prioritize their request. The court or the court clerk does not have to prioritize. When you send in a FOIA request, she is giving so many days to get that request to you. That's in the law. You don't get to jump to the front of the line just because you're Dateline or anybody else. Your request is going to be processed in the order that it was received. And that's how it should be. Okay.
Okay, I'm going to send it to your Facebook right now. There it is.
So they're asking, is there a way to know when the transcript will be filed? And the court reporter replied, an entry for a notice of filing of transcripts will be made in the online court docket when the transcript has been filed. Well, they were complaining before that they only had so many days left to get that transcript done for the appeal. That time should have passed.
Exactly.
Where is the filing? Saying it's done.
Where is it?
Put it in there because then they know they're going to be flooded with thousands and thousands of more requests asking for the transcripts.
Yeah, and you know what? That's what I keep telling them. Yeah, here. You know what? I've got that thing. I sent that thing right to you on Messenger. It's hot in here. So that's exactly what I said to him today in my latest response to the court. So I responded to the court already.
Do you know if the prison calls will be? We're trying to get them released.
That's exactly what we're trying to get. So that's what I'm saying is they're not even putting that on the record that I state in their law that says we can have this. So there's no refuting that. The Supreme Court's already ruled. How is she going to deny that? If she denies that.
Right. We put in a request for the original 43 seconds video taken by Libby. We requested the enhanced video and audio, the original and the enhanced for both video and audio of the 43 seconds taken by Liberty German's phone. We asked for interrogation number 1 that happened on October 13th and interrogation number 2 that happened on October 22nd for Richard
26th, I think.
26th, for Richard Allen.
Yep.
We asked for a copy of all 7 phone calls that were put into court as evidence of his confessions. We asked for a copy of the photo of the car.
Yep, and the video. From the Hoosier Harvest store.
What else did we ask for? I mean, we specifically asked. I think those were the main things we asked.
I think those were the main points I asked for was the phone calls, the video and audio, the phone calls and his car. And I think that's kind of
I know I
It is.
gave you a list and I kept adding stuff to it, but those were the main ones we wanted. If we could
Yeah.
get the other ones, that was gravy on the cake.
Yeah, it's because we wanted to show everybody. We wanted to show you guys what we saw in there, and they try to explain it to you because I can go out there and we can reenact it at the same spot all we want, but
Right.
it's not the same because we can't mimic her movements with the hands because we haven't had enough time to study that. Like the bridge guy video, I could close my eyes and tell you exactly what happens throughout every little segment of that video because I've analyzed it so hard for 8 years.
Right.
But this one, that's the first time I saw it was there. You know
The
what I mean? I mean,
original.
everybody. Yeah, we saw the whole video and it was like, whoa, dude,
And it was
that's not at
fucked up.
all what I thought it was.
No, it
Yeah,
was so messed up. It wasn't even funny.
it happened pretty fast. And for anybody to say, I was on Lauren Hidden True Crimes TikTok, reading comments and like talking and like commenting back at people and like telling them specific things, and they're like, what's the point of walking across the bridge fast? Because she posted a short video on it. It's got like 124,000 views. So people were like, what's the point of that? And I says, well, the point is people say that the guy couldn't have walked very fast on that bridge
Oh,
because
baloney.
yeah, baloney, you really can. And like people just don't understand, you know, without being there and
Mhm.
going and seeing everything that we saw in person, being at the trails, at the location with the family, the friends, you know, in the community, and just experiencing that takes you to a whole different world. And every single person that's come here says they have a different perspective
Oh
after
yeah,
they visited it prior to
absolutely.
coming.
Yeah. BH, yes. Transparency is what it's supposed to be all about. But why is Gull trying to hide all this stuff?
Because she's not, I don't know. She's, I don't know. Maybe she's just pissed off at the people that are talking all the crap about her too. You know what I mean?
Yeah.
Like the cops were saying how their lives were ruined or whatever. And I mean, I get it because people do that stuff to me and you and everybody else. They troll and
Yeah.
harass people all the time. So it's no wonder that these people, you know, go through what they go through.
Right.
But I mean, is she just taking it out on everybody, or is this like a defense team because the defense team, you know what I mean? Because she participated in that pilot program to say, yeah, let's go ahead and let cameras allowed in the courts in Indiana, and then turns around and says no more of that shit after Baldwin and Rosie called corruption.
Well, and let's make this be said. They didn't have to let Court TV or a news company come in and broadcast this.
Exactly.
It's obvious how they weren't able, couldn't even control the damn TV right, much less control cameras in the courtroom.
They couldn't even turn the TV on
I
that
know.
day. That was
And that is why we didn't get any cameras from the courtroom, because they don't know how to run this stuff.
no, not at all.
We all wanted to take the big fancy TV and drop kick it out the window.
That was a big TV, and they couldn't even turn it on, ladies and gentlemen. The first thing they wanted to do was play the Bridge Guy video. That was the very first thing they were going to play. And Steve Mullen, okay, think about this, everybody. Steve Mullen, the guy who the defense team is saying intentionally deleted evidence, recorded interviews. They intentionally did that, is what the defense team says now. Now, there's no validity to that. But on day one of the trial, the very first moment, Steve Mullen cannot get the television to work.
Yep.
He can't figure out the wiring. Okay, so they had another dude come over. So he started screwing with it. So then like Rosie goes over and he's screwing with it, and McClellan's screwing with it, and then Max Baker's messing with it, and he's like, here, I'm gonna try it right here. And then they couldn't get it for like
None of
15
them
minutes, and they're
could.
like, all right, well, forget that, everybody, ladies and gentlemen. So we're here today, you know, and it's like,
Right.
what?
We wasted 5 to 7 minutes with them tinkering with the damn TV for Nick's opening statement to show that video, and nobody in that courtroom could get it to work. Yeah, they said it was working 5 minutes before they started all this.
You know what? And it would have been a good way to start it too.
Yeah.
it would have been one hell of a way to start it. I would have been like, yeah, we're off to a good start now, everybody. You know, like that would have been epic. But we didn't get to see it on that first day, and I was kind of pissed off. I was like, dang, man, because they didn't play it, for like a few more days or something like that. Again, it was like the anticipation was killing me. And then I saw it again on closing arguments, that was the most powerful one to me. That was the best day.
Matthew, all I'm going to say on this is yes. Greeno will have a video coming out later about this.
Yeah.
Linda says, I met all them at Verdict Watch. They're pretty cool. Yeah, we're pretty ramped up, people. And if you all didn't know, Holly here is the editor of the Carroll County Comment. And we love what she has been doing with that newspaper.
Yes. You know what? We love it so much that I made a video about it, a podcast about it. Check it out on the True Crime Rewind. It's just about how we really do appreciate her and the work she does for the Comment, and the new direction of the Comment. It's becoming more modernized, more,
yes,
there's more information being provided to the public this way, and it's so beneficial because Delphi's always been stuck in the past. I mean, you've seen it. We're there at trial, everybody's standing there with their cameras and stuff, and horses and buggies go by, and everybody's like stops and looks. Okay, it's just old. They're old fashioned. They don't really they used to do everything by hand. That's why you see some of the orders written by hand, because that's their forms there in Carroll County. They're pretty old. And so just to see Delphi, come to a new future, like with the paper, really inspires me.
Yeah.
Thank you, Holly.
Great job. Court should provide the video footage. The problem with court TV, other videography, they focus the cameras exactly where the judge says not to. Megan Boswell trial is an absolute example of that. Makes me mad. But in this instance, if they knew this trial was going to be in Delphi for how long?
They scheduled it for a month.
Well, they knew it was always going to be there for the past few years. Okay.
Right.
So somebody should have learned how to use the cameras so that this could have gone out to the public.
Yeah.
You're welcome, Matthew. Sorry. Right now, I don't want to talk about that.
Yeah.
Holly says, I came into the trial in late October with someone else with the Comment covering it. Can't say I care for that coverage, but we'll see what we do from now on. Exactly.
That is so cool. So I pulled this up on the screen for everybody. What's up, Joe Newman? Miranda was just going to send you email. Cool. So I filed this and I asked the court. I told them.
I'm going to go to the bathroom while you're reading this.
Run it.
All right.
All right. I'll be right here. So, ladies and gentlemen, so this is obviously, as you can read it on the screen, it says Anthony Greeno's pro se motion to intervene and to compel access to public trial exhibits and unseal court records. I filed this with the clerk on 2/11/2025. And in this, I said the motion seeks, according to the Indiana Access to Public Records Act and Indiana Code 514.3 and the United States and Indiana Constitution, okay, that the release of public trial exhibits presented in open court, which are not subject to a valid sealing order, the unsealing of all court records previously withheld under the justification that additional bad actors may have been involved, a position now contradicted by law enforcement testimony, the recognition of independent digital journalists as legitimate media entities with legal rights to access public court records, which is basically me telling them that we, as what we do here on YouTube and what I do for a living, is considered media under the Indiana Code, and I can prove it. The public has a fundamental right to transparency in the judicial system. The court must uphold Indiana's public access laws, which mandate full disclosure unless a specific lawful exemption applies. A. Factual background and timeline of events. Number 1. Sealing of documents and justification given by the state. At the beginning of this case, the court sealed Richard Allen's probable cause affidavit and related documents, citing concerns that additional individuals might be involved in the crime. On November 22, 2022, the court held a public hearing under Indiana Code 514.355. Make sure that we're down here with me. Where are we at here? All right, here we are. 5.5 in Indiana Court Rules on Access to Court Records, Rule 6, and decided to unseal less than half of the affidavit while keeping the remainder confidential. So remember, ladies and gentlemen, there's still 100 and something pages still sealed from Richard Allen's probable cause affidavit. I'm asking for that to be unsealed. The state justified continued sealing by arguing that releasing the documents could compromise the integrity of the investigation and that additional perpetrators may still be at large. 2. Contradictions in law enforcement testimony. During Richard Allen's sentencing hearing, Lieutenant Jerry Holman testified that he does not believe that anyone else is connected to the case at this point. This directly contradicts the state's previous argument for keeping records sealed. Since the reason for sealing no longer exists, the records must be unsealed. Number 3, Judge Diener's prior order requires unsealing at the earliest possible time. On November 2nd, 2022, Judge Benjamin Diener issued an order requiring that sealed records be unsealed at the earliest possible time once the justification for their sealing is no longer valid. Therefore, the court must either unseal the records immediately or provide specific factual findings justifying continuing sealing, including proof of an imminent danger to public interest. FOIA and Access to Public Records Act, request for public trial exhibits and denial. On January 3rd, 2025, Mr. Greeno submitted a formal APRA request to the Access to Public Trial exhibits introduced in open court, including Liberty German's Bridge Guy video, unedited and enhanced version. 7, I wrote that exact number, 7 prison phone calls recordings of Richard Allen, surveillance photos and video of Richard Allen's vehicle taken by investigators, interrogation of Richard Allen's interviews with Liggett, Mullins, and Holman. The court denied access, citing pending appellate filings, despite no notice of an appeal being filed at the time. Unlawful transcript fees, we went over that earlier. Now, if you go through here, this is a legal basis for intervention in public access. So the Indiana public access laws and the presumption of openness. Indiana Code 514.3.1 establishes that all persons are entitled to full and complete information regarding government affairs. Court records are presumed public unless specifically exempted. Indiana Code 514.355 requires that a court must justify the continued sealing of records with explicit findings of fact. Case law supporting access to public records, Press Enterprise Company versus Superior Court, 478 U.S. 1986, the public has a First Amendment right to access court records. Richmond Newspapers, Inc. versus Virginia, courts must favor for transparency unless a compelling governmental interest justifies secrecy. YouTubers and independent journalists are legally recognized as media. Obsidian Finance Group, LLC versus Cox, established in 2014 from the Ninth Circuit Court. The court ruled that First Amendment protections apply equally to digital journalists as traditional media, which means we are considered media. Now, Gilk versus Cuniff confirmed that citizens, including digital journalists, have a right to record and publish public events. Indiana Shield law protects journalists from being compelled to disclose sources with no specific limitations for traditional media. And the request for relief was, I was asking for intervention for the limited purpose of compelling access to the trial exhibits and order the release of all those exhibits that I requested earlier. And so, are you back yet, Marv?
I am.
Okay, excellent. So that is what we went over, ladies and gentlemen, is all of that. And right here, this one right here is key. Number 8 is key here.
We can't. We just see 1, 2, and 3. You didn't advance the page.
Oh, it doesn't slide. Okay. All right. Well, I'm reading them to you. I'll put number 8 in the chat box, I guess. I didn't know that it didn't slide with it.
Yeah, but okay. So let's go back to us. There we are. Like I said in the beginning of this broadcast, I have had enough with all of this. Okay. I want a certain number of things to happen. First of all, I want special investigators to be put on this case and to look at every single terabyte of data that was given to the prosecution and the defense.
The discovery, we should have access to everything that was public except for the stuff that they saw that we didn't see,
Right.
which I would like to see.
But
like
at this
prison
point,
videos.
I would just be happy with investigators going through all of it, looking at the investigation that law enforcement did, what Nick McClelland did, what the defense did, and tell us if it was the right thing to do or not. Okay? Second, I want the transcripts from the trial released because there's a lot of misquoting going on when it comes to what happened in that trial.
You know what? We've seen a lot of that.
All the exhibits, except for the crime scene, the autopsy, and the mental health records for Richard Allen, released to the public. Everyone deserves to see it.
Everyone deserves to see it. And everyone deserves to see what's being filed with the court. You know what I mean? There's no reason that my motion has been sitting there since February 6th. I think I sent it the first time, or January 6th. Yeah, January 6th, I sent it the very first time. Okay. And they have not put that on the record. And I sent it from the clerk to the judge because I didn't know if the clerk was doing her job. Then I sent it from there. I forwarded that to the Carroll County clerk.
Yeah.
You know,
Carroll
and
County is not involved in this at all.
And they'll tell you, they're like, we don't have anything like that here. That's in Allen County. Now, Allen County, she's saying that they don't have some things. And then she says they took 2 weeks to organize it. So it's like, now, wait a minute. Hold on. It took 2 weeks to organize it. Like, seriously? You know what I mean? Like, she made a big deal out of that. Like, well, the court took 2 weeks to make sure that this was all put in 2 bankers' boxes. And it's like, okay, so that's their job. It's what they're supposed to be doing. Why does it matter it took 2 weeks?
And they're getting thousands of requests. Oh, well, you are the one that caused this situation, lady.
Yeah, she is. And you know what?
For yourself. You should have seen this coming a mile away.
And I've been defending her. You know what I mean? This whole trial, like, she's not corrupt. She didn't do, you know what I mean? She didn't do anything. And now she's pissing me off. You know what I mean?
I didn't agree with her in the beginning for a lot of things. This whole concept of this woman in this trial, I have never ever seen a trial like this where there's motions put in place and she just denies things with no hearing. I mean, look at how messed up the Karen Reed trial is right now, the second trial. And at least that judge has freaking hearings on the motions and lets the two sides present their cases and then rules on it. But at least they got the opportunity. Go from the beginning is like, nope, denied.
Well, so primarily, I'd say all judges are like that in Indiana. No, they're all that bad.
No.
You don't think? In Indiana?
No.
Just,
I don't know all of them, but a lot of them, yes, but not all of them.
To me, the court system always feels like it's just made to screw the defendant. You know what I mean? Like, I mean, I felt like I was always screwed when I went in there. Yeah. Chances are I was half guilty most of the time.
So I have never agreed with her on the fact that she just denies things without a hearing. Okay.
Yeah.
I've never agreed with that.
Yeah, I don't agree with that either. She shouldn't just. Well, I mean, she takes it. There's two ways they can do that. I think she's taking it and doing it as their argument is their motion. So when they do the defense files and the state's response or defense's response, that's their arguments, and she wants to see it in writing with
their
case law.
arguments, but you see this all the time in other trials in other states. That's their arguments, but they should have the right to stand before her and present that and more, because you're not going to put everything in an argument. Otherwise, they would be hundreds and hundreds of pages long. And she's not going to accept that either. So,
You're right. You know what? All right. So I gotta go in about 5 minutes.
yeah.
Okay. But I wanted to. I don't know. I just wanted to speak. I wanted to speak my opinion on this because it's frustrating, and it's frustrating that I don't care that nobody. In a way, I don't care about the recognition part of filing that document, but what I care about is that people should know the things that is going on here. You know what I mean? Like, I'm trying to get this stuff. Other people are trying to get this stuff, and we're being like given the runaround. First, it's
Right.
You got to call, and then it's okay. Now you got to put it in writing. So then you got to request it. So I requested it all in writing specifically, and then they say, well, now you got to put the exhibit number. What's next? If there's another hoop here, there's
She's
something
not
wrong.
even following the FOIA request rules. That's what pisses me off.
Exactly. Well, they have 7 days to respond.
Own rules on
They
this.
have, yeah, they have 7 days to respond. It doesn't say that they have 7 days to give you everything, but it does say within a timely manner. You know what I mean? Like a reasonable time. And, when you look up reasonable time, typically a reasonable amount of time is 10 days, but they can get up to another 20-day extension. So 30 days is a reasonable amount of time.
Yeah.
And it's been past 30 days, and my letter that's been written to the court on January 6th still has not hit the docket or been scanned into the record.
Right. Because they can't keep up with all the requests.
There's something wrong with that. I don't think they're getting all those requests. You know what I mean? I don't think they're getting a whole bunch of that because, as you see, only two things have been filed. So they're supposed to file every single thing, like all those letters that were written to the judge.
They're not. That's the problem.
They're definitely not. At least we know that they're not doing at least one of them. And you know what? It's because they sealed some of that stuff in the probable cause affidavit at the beginning of the case, citing grounds that they wanted it sealed because they believed that there was other bad actors. Well, at trial, Jerry Holman said he didn't think that anymore, that nobody else was involved but Richard Allen. Therefore, if that threat is gone and that's the reason that they were sealed, you have to unseal them. You know what I mean? And that's exactly what I'm shooting for here, is I want them unsealed, And I would say I'm probably kind of a smart ass in my next letter to her, my response to her order, which is basically explaining that there was delay of more than 30 days and inability to place, the instrument within the docket and on the record. And when she asked the questions on there, you see, everybody, this is what's funny, is in this order that she ordered, she's responding to almost verbatim words that I said in my motion, but my motion wasn't included in that.
Mm-hmm.
And she wasn't responding to the things that they had asked for because they didn't really say all of that. But I said specifically those words that she used, and she cited those, but responded to them.
Right.
It's weird.
Holly, this is exactly why so many people are hollering about corruption in these counties.
And they're blaming Carol.
And because of the way they think that they can make their own rules and do their own things.
Yeah. The judge wrote response to section. This is my response to section 8. She said, vague and overbroad request. The court stated that the requests for public trial exhibits are vague and overbroad. I respectfully submit that my original motion clarify and unambiguously identified the exhibits sought. For example, I specifically listed them, right?
Yeah.
Every single one of them. Now, so I responded to each one of the things when she says, any and all, you've requested any and all phone calls of Richard Allen. Which ones do you want? I'm pretty sure. So what I did, and this may be kind of an asshole move, but I went ahead and defined clarification on the terms any and all. So I wrote, for clarity, I define these terms as follows. Any refers to one or more without necessarily including every item within a set, or all means every single one without exception. For example, a request stating any and all documentation, recordings, or videos requires every single item in existence that meets the description. However, when a request is made for specific exhibits, the requesting party must provide precise exhibit numbers. In this instance, since I have clearly identified the items in question, I respectfully request that the court provide a detailed list of the corresponding exhibit numbers and ask them for them. So it comes to the point where the court is telling us that they don't know what any and all means.
How stupid can you be? Any means anything and everything you have.
I feel like I'm writing a letter to a little kid. Like,
Mhm.
you know what the word any means? Huh? Let's spell it A-N-Y. You know, like, geez, you know, so I'm writing them back for us and asking for the same items, but I'm asking with the exhibit numbers.
We did get some of the exhibit numbers. I have to go through my notebooks tonight and get you the other ones, or find somebody else who has them. And yes,
I think I might have them now. Thank you to special somebody out there. I think that,
well, I'm going to try to give him the day of the trial that the exhibit was shown and the exhibit number. That should be more than enough.
that is more
over and beyond what is needed to give them in a FOIA request at this point.
You know what? You're right, because now we're doing the work for them. Okay. Now here's oh yeah, the one thing that I wrote in there, because they said they took 2 weeks to do all that, right? To organize it. And so I thought, well, you know what? Since the court took its diligent time in organizing all of these documents and all these exhibits into 2 bankers boxes, then whoever organized that would know specifically where these exhibits are and what they are.
They should have a list.
They should have knowledge of it. Yeah, because they dealt with it and they know, okay, this is exhibit 1. It goes here. That's this.
Yeah.
Make sure that's in there. You know what I mean? They would have had to know that.
Yeah.
So I don't want to hear no more excuses on, well, we don't know, or we don't have access to that, because I know they do now. She said it in her own words.
Exactly.
So that's just asking too much, because they don't ask for that every single time. Let's go ask another court and see. I should film that. I should film going asking Tippecanoe County Court, or not Carroll County, Tippecanoe, because it's the next one, and just go in there and see how easy it is to get something like that on a different case.
All I've ever had to do is give them a case number. Say, I want this, I want that. I didn't even have to give them the actual name of the documents. I just told them what I was looking for and what I wanted. And if they had questions, they sent me a question back and then said this is how much it's going to be. I send them a check and they send me the information, or I have it picked up. So
exactly,
there's no reason we're having to jump through these hoops.
No reason whatsoever. And I'm going to continue to, I may not do a bunch of live streams, everybody, but I'm going to continue to seek the truth in this.
We are going to press on. And if we have to go above Gull's head, I think it's time to do it.
So there may come a time here in the near future that an attorney may need to be hired here.
Mm-hmm.
Seriously. And so, like, if that comes to that point, ladies and gentlemen, that's where you could come in. I mean, if they can raise $42,000 for a child killer in 2 days, then we can raise money to combat the bullshit and make the court comply. I mean, we've done it once with the fees. and we can do it again. So I'm going to have to roll out of here, but I just wanted to say thanks to everybody that's messaged me in the last couple of days over the tragic incident that happened, and just expect a video coming out on my channel about that and my thoughts on that horrible situation.
Yeah.
And I'm going to leave it at that for that. Okay. So I don't want to say anything because it's troublesome the way it is. Yeah. So
it's
very troublesome. So
yes.
Anyway, thanks for having me on here, Marv. I'm going to dip out. I got you the clips of the crime scene and stuff like that pulled into here.
Awesome.
So you can see what it looks like. It's over there on the right above Judge Gull's order.
Okay.
So I don't know if there's music to it or not, but
I'm not going to show that tonight, but I will show that soon.
Okay. All right. Well,
thank you for all your help.
No problem. I love digging into this stuff. The legal part is what I love. So on that note, everybody, I'm Anthony Greeno from the True Crime Rewind and True Crime Investigates. Until next time, you keep it Southern style, y'all. Peace out.
Have a good night. All right, everybody. I'm telling you, I got a doctor's appointment in 2 weeks, and I swear my blood pressure is probably going to be out of the roof. And when he asked me why, I'm going to have to tell him. But let's see here. I don't think it's exactly the same as what she did to the defense team. Yes. Did she limit the defense team? Yes. But was there precedence to do that, or legal means to do that, reasons to do that? Yes. You know, I don't like that they were limited on the amount of money they got. They should have been able to do, if they wanted to request DNA testing on the male DNA, they should have received money to have that testing done, in my opinion. Okay. The third party defense stuff, I agree. There has to be a nexus. There has to be a connection. And the connection that they gave the court was not enough, in my opinion, to let that in, to bias the jury. Now, we're finding out that all this other stuff existed after the fact. Why wasn't that given to the defense? I'll completely agree with that. Why weren't the letters given? Why wasn't the interrogation or the interview of Reese Davis given to the defense? Should have been. And if it wasn't, then Nick McClelland's ass needs to go on the frying pan for that. But like I said, I think going forward, and you know what? At this point, I'm hoping the Supreme Court does listen to this. I'm hoping that they have a hearing on it all. And once and for all, we are told from the Supreme Court what Judge Gull did correctly, what she did incorrectly, and whether that warrants a new trial or not. That's who I want to hear it from. So I'm hoping that they do have a hearing. Now, is that hearing going to happen anytime soon? Absolutely not. But one day it will. I'm hoping. And like I said, and then we're going to get answers on what was done right, what was done wrong, what is actually appealable, and go from there. And then we're going to get a decision from that group of judges. And that will tell us what was done right legally, what was done right, what was done wrong, and whether Richard Allen should have a new trial and the third party be allowed. All right, let's see here. I don't know. That's going to be all up to the Supreme Court, but I seriously, at this point, I've just had enough of this case, of too many coincidences, all the BS, and I want to hear from the Supreme Court themselves. What was done right, what was done wrong, and if the wrongs were so bad and would have changed the verdict in the trial, then have a retrial. And then I hope Judge Gull is removed. I hope Nick McClellan is removed. And I hope the defense team is removed and they bring in all new. Don't bring Liberato or anybody else who has been currently in with this case. Because like I said, I want special investigators to also look at everything. Everything the police did, everything that the prosecution had, everything the defense had for their discovery, all of it. I think that's the only way that we are going to know what was done correctly and incorrectly in this case. Special investigators and the Supreme Court telling us. And that way, all of the bullshit stops. And we may have to wait a couple years to hear that. But in my opinion, it'll be worth the wait. Yeah, I agree. They probably will. But at least for my own personal sake, I'll know. Let's see here. They definitely need to let this case rest, but they just keep bringing up. But we don't know for sure if it is BS at this point, Jackie. That's what I'm saying. This guy is not going to send out 8 letters. And if you read the response from Nick McClelland, he obviously received some of those letters because he puts facts in there that were not given by the defense in their motion. So at this point, who fucked up? What is the truth? That's what I want to know. Let's see. I'm not sure if it's related, but as far as the Good Old Boy Club, McClellan was bunkmates in college with Carroll County Judge Shane Evans, and some recent rulings in Shane's court with McClellan. I'm sure. We can't because those aren't even public either. I want to see those. I want to see it all. He may have, but we don't know for sure. Yeah, I heard that too. I remember, you guys, when I used to watch trials and they were boring and lame and just facts were given out. And now, today, it seems like every trial I watch has issues. Every single one. And it's not just one or two issues, it's multiple issues. Well, sassy or snarky sass angel, let them know I'd like to see it. Yeah, but they may not have seen everything. That's where I'm going with this now. Because of all of this stuff that's coming out, they may not have seen everything that they should have seen. I said in the beginning, I agree with their decision based off of what information they were given. But were there some things, and I'm not talking about the oldness stuff, that stuff. I'm not talking about that not being introduced, but I am talking about some of these other things that have freshly came out, not being given to the defense as far as we know, if they're telling the truth. We got to hear, I wish we heard from the prosecutor on that, but you notice that Gull didn't even give him the opportunity to respond to that, all that. She just denied everything. So, I'm not saying I know more than Judge Gull. I just want to know that everything that happened in that trial that I sat outside for and was in there numerous days, almost all but I think a total of 3.5 days, 4 days. I want to know that it was done right. That's what I want to know. And that's why I'm calling for special investigators. And that's why I'm hoping that the Supreme Court eventually picks this up and has a hearing and gives us their facts and findings. Because that'll clear up a lot in my eyes. And yes, I do think it's a time for the appellate attorneys to take over. Let's see here. All right, everyone. Well, thank you for joining me and letting me rant and get all hot and heated. Not exactly what I planned on going over today. I was going to go over the actual motions, responses, and the judge denying them, but I think we all heard that. We know what it was, what they wanted. I do not feel it was right for her to deny those motions without a hearing. She should have had a hearing and let both sides argue their cases before making her decision. That is my opinion. Thanks for your dedication, Marv. If we don't ask questions, we don't get answers. Right. All right. So what is up next? If you're following the Tabitha Shuck Rains case, I did do a live last night, and I read the foreword, the introduction, and chapters 1, 2, and 3 of the book. Oh, I need to turn my background up. Hang on. All right. What Happened to Tabby by Josh Sigler. I'm reading the book online. I got permission for him to do this. I'll be recording the next few chapters here in the next few days to get that out. Tomorrow, we are going to talk about what is going on in the Harmony Montgomery case. There are things that have gone to the Supreme Court in that case too that we need to discuss. And then Friday or Saturday, we're going to start talking about Karen Reed. Next week, I'm going to try to get a good friend of mine on here to start going through the Madeline Soto case with us, because that's another trial that's coming up this year. So that's where we are. And I'll probably have some other things for you, some shorter video type things, pre-recorded videos for you in between that. But tomorrow I'm going to do Harmony, and then Friday or Saturday I'll do the Karen Reed thing, because I have to look at some more things in that case. Make sure I totally understand it. All right, everybody, have an awesome night. If you're in this cold weather, please stay warm. I think with the door shut, I finally warmed up. I can take the bathrobe off and act kind of like a normal person. Enjoy the rest of my night. I hope you enjoy yours. And remember, justice matters for everyone involved. Have a good night, and I'll see you soon. Bye.